All right, class, settle down and pay close attention. Welcome to this explainer. Today we're undertaking a high-yield, purely exam-oriented masterclass tailored specifically for your KSLU final semesters. We are dissecting the Transfer of Property Act, 1882, and we're focusing exclusively on Section 118, the concept of exchange. See, if you want to know exactly how to structure a flawless 10-mark or 16-mark answer, the kind that leaves the evaluator literally no choice but to award top grades, well, you are in the right place. Have your notebooks open? Okay, let's dive right into this.
Here is the structure we're covering today. 1. Introduction and definition. 2. Essential elements. 3. Modes of transfer. 4. Rights and liabilities. 5. Distinction between exchange and sale. And finally, 6. Illustrations and case laws. This is your mandatory syllabus, and it's the exact table of contents you must recreate on the first page of your answer script to signal total conceptual clarity to the examiner.
All right, starting right off with Section 1, Introduction and Definition. Now, when you begin your answer in the exam hall, write your heading clearly and boldly. Please do not bury your points in long paragraphs. State clearly that exchange is one of the specific modes of transfer of property where ownership is transferred for a consideration other than money governed by Section 118. Then, you write this precise statutory definition exactly as it is. Section 118 states, when two persons mutually transfer the ownership of one thing for the ownership of another, neither thing being money only. Listen to me, I want you to literally underline that critical phrase in your exam, neither thing being money only. The crucial takeaway here is that if pure money is the consideration, it's a sale. If it's property for property, it's an exchange. Memorize this verbatim.
Moving on to Section 2, Essential Elements. Once you've established the definition, you have to command the evaluator's attention by listing these 4 elements distinctly under a new heading. Clear, structured organization is exactly what KSLU evaluators look for. They don't want to hunt for your knowledge. You must present it to them on a silver platter. Number 1, mutual transfer of ownership. 2, both parties are transferor and transferee. 3, consideration is not money, or at least not wholly money. And 4, property may be movable or immovable. A top-tier student doesn't just write these out as one long, messy sentence. You list them as distinct bullet points, exactly like this, to effectively pad your 10-mark answers while maintaining absolute academic precision. Every bullet point is a mental tick mark for the examiner.
Let's look at Section 3, Modes of Transfer.
You cannot skip the procedural aspect of the law. Many students focus entirely on the theory and completely forget the procedure. Omitting this will severely cost you marks because the law is practically useless without knowing how to execute it. So here is the stark legal reality of execution. For a movable property, it must be made by a registered instrument, just like a sale. For movable property, it can be effected by delivery or a registered document. Pay very close attention to the diction here. I strongly warn you to use the exact Indian legal phrasing. Write registered instrument, do not just write paperwork. Write affected by, do not just write done by. Also, make a note that the general rules of sale apply to exchange as far as applicable. Using the correct statutory language is what separates the first-class students from the rest of the pack.
Next up is Section 4, Rights and Liabilities. Under this heading, you will state that the rights and liabilities are the same as those of a buyer and seller in a sale. But here is the golden nugget. Each party has a dual capacity. They are simultaneously the buyer and the seller. I instruct you to specifically highlight this exact term, dual capacity, for the examiner. Draw a box around it, underline it, whatever you need to do. It brilliantly illustrates that you understand the reciprocal nature of the transaction, where A is selling to B and B is simultaneously selling to A.
Section 5, Distinction between exchange and sale. Pens down and listen to me very carefully right now. This distinction is the absolute core of your exam question. It is the primary battleground for points. If you mess this up, you lose the question. I demand that you memorize and draw this exact distinction table in your exam script. No paragraphs of differences. Draw a clean table with 3 columns: basis, exchange, and sale. Row 1, consideration. In exchange, it's property for property. In sale, it's money or price. Row 2, nature. Exchange is a mutual transfer. Sale is a one-sided transfer. Row 3, parties. In exchange, both are transferors and transferees. In sale, there is a distinct seller and buyer. Row 4, money involvement. Exchange is not money only. Sale must be money. And finally, row 5, the governing section. Exchange is section 118, sale is section 54. Recreating this exact table format is a guaranteed strategy to score top marks. It's clean, it's precise, and it's undeniable.
Finally, section 6, illustrations and case laws.
We are approaching the climax of your answer here. Legal theory must always be backed by practical application and landmark judgments. You simply cannot secure a full 16 marks without proving to the evaluator how the courts interpret these words. I want you to write your illustrations out like mathematical formulas on a blackboard. A gives land to B and receives another land in return. That equals exchange. A transfers land to B for 5 lakhs rupees. That equals sale. Now what's really interesting is this third scenario. A transfers land for land plus 1 lakh rupees. This equals still an exchange. Why? Because the consideration is not wholly money. It's property accompanied by money to balance the scales. As long as the consideration is not purely money, Section 118 holds firm.
Now we move to case law. Stop what you are doing. When you write this case in your exam, I want you to write it in a separate, boxed format right in the middle of your page. The case is Ram Christomandel v. Donkistomandel. Let's break down the facts briefly. In this dispute, 2 parties agreed to swap parcels of agricultural land. Later on, one party tried to invalidate the transaction by claiming it didn't meet the legal formalities of a sale regarding the payment of a price. Now, the court's ratio decidendi here is absolutely critical. The court held this was entirely an exchange, not a sale. Why? Because the absolute relevance of this judgment hinges on the phrase mutual transfer. The court firmly established that when ownership of property is mutually transferred without the fixation of a monetary price as the primary consideration, it squarely falls under the nature of an exchange. You must aggressively highlight the phrase mutual transfer in your answer. That is the exact ratio the evaluator is scanning your paper for.
Your second mandatory case law is CIT v. Motors and General Stores Private Limited. Underline this case name immediately to capture the evaluator's attention. Here is the brief background. This was actually an income tax case. The assessee company transferred a cinema house and, in return, received preference shares in another company. The taxing authority tried to classify this transaction as a sale in order to levy specific taxes on it. However, the Supreme Court ruled in favor of the assessee. The ratio decidendi, the transaction was an exchange. The absolute relevance of this case is how it distinctly defines consideration. Because preference shares are considered property in the eyes of the law and not mere money or price, transferring a cinema house for shares is fundamentally property for property. I want you to hammer home this point in your exam to prove your conceptual clarity. If the core consideration is literally anything other than pure money, the transaction legally evades the definition of a sale under Section 54 and becomes an exchange under Section 118.
So, to summarize everything, an exchange involves the reciprocal, mutual transfer of ownership where the primary consideration is not purely money, whereas a sale is strictly a transfer for a price. Understanding this specific distinction dictates the entire legal consequence of a property transaction. As we wrap up this explainer, I'm going to leave you with a strict exam-level question to ponder for your advanced legal studies. If land plus 1 lakh rupees is still legally an exchange, at what exact threshold does the inclusion of money legally eclipse the property value and transform the transaction entirely into a sale? Think like a jurist class. Good luck with your preparations.